Hi guys, how are you? Okay, just a second, I'll share the screen with you. Yeah, yes. So I hope everybody's fine. So, all right. So I hope that you have gone through the previous lecture, and if even if you haven't gone through that, please go through the same and read the basic things and basic points that we have studied. And we have studied just the very basic concepts like what is legality, what is ethics, what is court, what of course what is court craft and everything. And Supreme Court rules, why do we need Supreme Court rules, why do we need High Court rules, and how are rules different from how are rules different from laws, and what does it need, what does it take to be a rule, what does it take to be an act or a provision or a law. So what is the process that these things have to go through. And then we had studied like advocates in their course of conduct. And the very first thing that we had studied is like we also studied why do we need this particular subject, what do we get out of it, all those things. And then we studied like what are the things that advocates must be possessed with. And advocates, like these are some virtues that advocates must have or must conduct themselves with. And what is the course of conduct of a court, and what do we need to do that. How how do we have to uphold the dignity of the constitution, or in the court. All those things we had studied just a bit. And so again we'll continue with the same thing with the very first topic and the second part of that. And there had been some suggested readings that we had suggested to you. Again, I told you it's interesting if you go through the commentary. It's interesting, and contempt of court particularly. It's very interesting subject, and we must go through that. And you have to keep reading the daily newspapers and all those articles and news that actually come, and so that you can actually relate to the concepts that you study elsewhere. And the two, these things I've also mentioned here. The sources that you have to read from, like a lot of people might say you don't have books, and you may not be, the books may not be readily available. So but that's fine, if even if you don't have books, you have ample of material available online. So that's you need not worry about that. So the part second we're going to do, and the conduct and all those lamps and all the virtues that we had studied in the last class, in the last lecture. So I would say that you must be, whenever you choose to be an advocate, whenever if you choose to be an advocate, so you must be carrying all those things, carrying not physically of course, but you must be inculcating all those things so that these virtues you have, and what it takes to be a good lawyer, good advocate, and what is the journey that you have to learn from. So all those things you have to read. So again, the advocates and their conduct, that continues if we talk about that. So yesterday, in the last class, basically, not yesterday. So in the last class, we had studied that, and these lamps, these virtues, you should have if you want to succeed in the field of litigation, or you want to be a good advocate, you want to leave a good legacy behind. So that is important, and so is this. So again, now we will be focusing on the part ethics. And as we all know, what yesterday, in the last class also we had studied what ethics, what does it mean. So ethics, it differs. I told you it differs from person to person, people to people, and then it differs from various people, various subjective. It's a subjective concept. So ethical, you need to be ethical, of course, but what is ethical, that may vary from people to people. So basically it's the test of your character. And then of course, character as in not, character as in like what strong values do you hold, what principles do you hold? Are you a principled person or not? So all those things, that people choose to be good, people choose to be, a virtuous person, people choose to be, a person who's a person of ethics, who's a person of values, who's a person of high moral values. So all those things, and of course, there's a lot of gray area and everything, but yeah, of course, certain things are just very, very fundamental that way. So philosophically speaking, so ethics, they outline what is a good person. Like, again, if you talk about what is a good person, good, of course, good is something that actually is subjective. It's a thing that we are not sure about. If you're good, if I'm good, if we both are not good, or who's a good thing, what is a good thing. So those things we have to calculate, or we have to see according to the facts and circumstances. So not certain things are just fundamentally good, fundamentally bad. So that you have to be, yeah, taking care of. So we are talking about those things. If you're an advocate and you have to conduct yourself, you have to behave yourself. So you have to be an ethical person. So something which is outrightly immoral, of course, that cannot be accepted. All right. So society, whenever we talk about ethics, whenever we talk about good or bad, so we just have to see as for the, as from the eyes of the entire society, the whole society, so that what is acceptable, what is unacceptable behavior, what is not an acceptable behavior, all those things. And when we talk about the conduct in particular, example, Supreme Court rules and High Court rules and advocates and acts and all those things. So then the ethics, they are not just moral ethics, they are just not societal ethics, they actually become legal ethics. So legal ethics, you may say is oxymoron, as in it may be legal, or it may be overlapping though, but yeah, everything doesn't, every time it doesn't have to collide, or they don't have to, both these things don't have to fit in the same circle. But having said that, if you're talking about ethics and legally ethics, so that means that you have carved out a principle, you have carved out a certain acts or laws or rules, whatever you may call it, and then you have to behave yourself accordingly. And then it is no more a legal, it is no more a legal, it is no more a moral thing. It has actually become a legal obligation on you. And for example, if you actually appear before the Supreme Court, you have to be very well uh, within the conduct, and you have to properly dressed, and you have to be properly behaving, as whatever is required according to the book and everything. So ethics, they teach you, or they they may be, or encompassing learning that what is correct and what is incorrect. So according to you, according to the situation, so you have to see what is acceptable, what is socially acceptable, what is not, and what is, that's a social conduct. So but if you're in a court, or if you are talking about um, behavior or behavioral aspect in within the courts, or within the premises of the courts, you have to see that your conduct is a conduct that has to comply with the provisions of the Supreme Court rules, or the High Court rules, or the Advocates Act, and all those things. So it's no more just a social obligation, rather it's a legal obligation, that the goodness, the correctness has to be matched with the provisions which are applicable, all those things. Okay. The most ethical and right decisions have various alternatives and have far-reaching consequences. What does it mean? So, what is most ethical, or what is the right decision? So again, theoretically speaking and subjectively speaking, so once we have actually gone past that stage, that this is an ethical thing, and this is socially accepted, this is socially acceptable, and socially considered ethical, so then you have to see that if you do that most ethical thing, so of course the consequences, they have far reaching consequences. So so that people actually, for example, if we are talking about a certain milieu, milieu. Okay, so so in that case, if you're talking about certain uh, these things, ethical acts, so they actually go far away, far beyond your imagination, that actually that you are within the conduct and you are actually behaving as per the rules and rules which are applicable. Okay, so besides the things what we had studied in the last lecture, so there are the certain other things also that that an advocate must be or must be inculcating in his or her behavior, that we had spoken about the nobility of the profession, and law is a noble profession. And why is law a noble profession? Because it deals directly with justice. Okay, so if we are talking about justice, so justice, it finds its uh, ways, it finds its application and roots. Where does it find its roots? The constitution, in the preamble itself. So we, the people of India, having solemnly resolved to constitute India into a socialist, secular, democratic, social, all those things, and then to secure its citizens justice, equality, and all those things which we definitely have read already. But justice, what kind of a justice are we talking about? Social justice, and economic justice, and political justice. Get it? So as maybe we have, I don't know if we have talked about it or not, but yeah, all those justices, and they're deliberately, in a they have deliberately been put in a I won't say chronological way, but in the same manner as it is put. So it's very important to attain these these principles, that everybody must have, and not only justice that you must attain to, and you must be having it an access to the justice. So, and advocates are the carriers basically. So, who bring you to the doorstep of justice. So, for example, if you are to get justice from the court, the advocates need to help you do that, need to help you achieve that. So, this is a very interesting and important concept, that nobility, we have to see, or this nobility of this profession in our constitution, because we are talking about justice and we are dealing in justice here. Justice, the first and the very first thing that justice actually comes from is the preamble, and of course the entire constitution and various laws, they also talk about that. But if you talk about the preamble itself, so in the very beginning, it's mentioned, it finds its roots, that social justice and economic justice and political justice you have to attain, and you have to help person attain these principles. And again, advocates are the supporters, the helpers, and hence it's a very noble profession. If somebody helps me attain my justice, well, justice is something that I actually live for, and justice is something that it should, as they say, it should not be only done, it should be seen to be done. And seen to done, as in it should be, I should be fair, I should be feeling that justice is being done to me. Okay, so my advocates and your advocates will help you do that. And you must have heard the pro bono cases, and a lot of people, they fight cases pro bono and they don't even charge penny. So that's that's the beauty of the subject, that you can actually fight for it. You can actually, if it's one of the noble professions. The professions are also very noble, in fact. But this actually directly deals with justice. And when somebody, whenever anybody feels infringed, any right, any maybe fundamental right, maybe a constitutional right, maybe any other legal right feels to be violated, if you feel that it's violated or infringed, so in that case, you directly seek out for justice, and then the advocates help you attain that, help you get that, and of course through the courts. So this is the beauty of the subject, that you help a person who is aggrieved, who is not satisfied, and you help that person get the desired results, and who has been, who has been done wrong to, who has been wronged in a way, in any way. Okay, so again, it's commonly said that legal profession is notable, noble, and it is indeed true that it should be noted. However, that the profession's nobility is anchored and the observation and compliance, and you can always read these things. So these are just the sayings of and or that I've jotted down from various books. And of course, the most important scope of the legal ethics is to uphold the dignity and the order of law profession. So, for the fair transaction, like we have just spoken about it, that if we are talking about law as a profession which helps you attain justice, so, you have to uphold the legal principles, you have to uphold the legal ethics, you have to uphold the dignity and the order of law profession. So, as they say, you yourself cannot be the violator of law. So if rules are there, if rules are to be followed, you must follow them, and you must be working within the framework of your respective domains. So it should not be the case wherein you are found to be violating various rules or regulations, or maybe you're not properly conducting yourself, or maybe you are unethical. So even that, so legally unethical. So whatever is legally ethical, you have to abide by that. You uh, just cannot take the high road, or just cannot take the excuse that this is not a law, this is not a not an act or something, but this is legally unaccepted. This is legally unethical. Okay, so and like last class also we had this thing, that conduct in the court. So you must be behaving yourself in the court, like whatever things that come to your mind first. If you are an advocate, you are to you are to wear particular uniform, you are to wear a robe, you are to wear a gown, you are to wear black and white, or black, or these things. So you just cannot wear a jeans, or you cannot appear before a judge within in your casual. You must have seen in the times when maybe a virtual hearing is happening, and then people are not properly dressed, and so basically that way you're demeaning the decorum of the court, you're demeaning the noble profession of justice. So yes, like in the last class we had also read this thing, that you have to, the lamp of fellowship, the lamp of industry, you have to respect various things, you have to respect things, and when you respect things, then you also get the respect, and then you learn on the job. Okay, so the conduct, and in order to in order to help advocates, or help people maintain the conduct of the court, or judges to maintain the conduct of the court, there are some rules. There are the rules made by BC Bar Council of India also, and there are the rules which BCI talks about and keeps altering, keeps amending, and keeps coming up with new laws and regulations and maybe in various times and various uh, as per the need of the hour, they keep coming up with the PCI rules. Like for example, earlier it used the Bar Council of India exam used to happen twice a year. From past some years, that has been happening. That has been taking place once a year, if I'm not wrong. So they keep altering these things, and they keep uh, for the in order to become an advocate, they keep the syllabus to be handy, and so that you take the bar exam, and then you clear the bar exam, and then what is the process, all those things, and how do you conduct yourself in the court, and so that you influence the court positively, so you don't actually end up saying something or hurting the sentiments of the court, or don't end up saying something which is abruptly which is not necessary, also which is not legally and ethical as well. So as it's talking about rule 3 prohibits advocates from communicating directly with judges in connection with pending cases. So these things, excuse me. So these things that there's so many rules, just like rule 3, that if you're talking about the pending cases, so directly you cannot, you're prohibited to directly approach a judge and talk about pending cases. So this is the conduct, this is one of the provisions in conduct, and you need to conduct yourself, and you have to abide by the rules, as we had studied earlier also, which are mentioned in the Supreme Court rules. You have to adopt the process, and then the BCI rules, all those rules you have to, Advocates Act, may whatever rules are there, you have to abide by all those rules. And you must have read that in so many cases there have been so many cases which talk about the tussle between maybe the lawyers, or maybe unethical, maybe they're not proper, or maybe contempt proceedings, so many things which we keep seeing, we keep noticing that happen in the courts. So that's the conduct of the court that you have to study. See, this is very important and interesting. Conflict of interest, and you must have studied in the CPC, like what is conflict of interest. And as far as CPC is concerned, conflict of interest is something that, for example, you and I are at the loggerheads, you and I are at the are fighting a case. So if I implead one more person or make a party, let's say if I make X a party to the suit as well, so this X should not be having a conflict, and that's a separate concept actually, that whether he or she can be having a conflict of interest with me, the former defendant, that we so that this person does not go against me or my decree tomorrow. So conflict of interest basically is, I cannot have the positive interest in that matter. For example, I cannot have the positive interest in the matter, and in this particular case, so it means that, like if I am defending your case, and you're my client, and then the person who is against me is somewhat related to me, or I have some interest in that person's estate also, or somewhat related to, if I know that person, or so that tomorrow it may be something which might hamper your justice. So what we need to keep in mind, the ultimate object is to keep in, which we need to keep in mind, is to uphold the dignity of the profession. And if I actually, do something which gets into the conflicting nature, which gets into the conflicting interest, so in that case, this is not good for the justice also. This is not good for the profession as well. So that's something that we must avoid. That's something that we must, with the provision of the upholding the dignity, that we must adhere to. So advocates, they must not, you know, uh, they must not have conflict of interest between the current or potential clients. For example, if you are my client today, and the person who is against against you, against us, in fact. So I may have an interest with this person, maybe my relative, or maybe my friend, or maybe I have some proprietary interest there. So, or maybe tomorrow I can have that, tomorrow he or she is going to be somewhat related to me, so all those things. So there should not be any, that you shouldn't suffer, the current client or a potential client, and versus the person who is against us. So there should not be any conflict of interest. Accordingly, advocates must turn down the opportunity to act where they or their partners, spouses. So, of course, for example, at the same time, for example, I'm fighting your case, or maybe my wife is fighting the case of the. That's not directly a conflict of interest as such, but that it may actually result in a conflict of interest. So I should turn it down. That this case I shouldn't be taking, because my wife is taking the opponent's case. So it might be a case of conflict of interest, because we may collide, or collision might happen, or something of those sort. So you must keep in mind that you have to ultimately uphold the dignity of the profession, and you have to attain justice. So there's something service fees, and it's not something like I should or anybody can teach you, or you, like for example, if I tell you what should be the fees or what should be, it's something that is, and it's subjective as such, because some people just some great senior advocates, they take cases pro bono, they some or in fact, it's not a rule of thumb that whereas, budding lawyers or young lawyers don't get paid much. It's not that anything is not, this sort is not true. Like if you know your stuff, if you're good at it, you will get paid. And if you think that you need to fight for justice, basically what it wants to tell us is that it should not just be about money. Like money, of course, everybody wants to earn it and everything. So it should just not be about money. Whenever you think that justice is hampered, so you must, fight for it. And while you have to make your bread and butter out of it, but yeah, at the same time, you have to fight for the justice, because it's a noble profession, and nobility lies in fighting for justice. And meanwhile, you can earn, you should earn as well. Of course, you will earn, but at the same time you have to fight for justice, and you have to keep in mind that justice is something that actually ultimately it should prevail. Okay, so right. So and disclosure and withdrawals, that's something we have studied that in evidence also. We have studied that in CRPC as well. That if there is a CRPC may basically that's for judges. If a magistrate has a has any interest in the state, so should be transferred or something. Should the matter should be transferred. So that's. But here, disclosure and withdrawal, when advocates choose to accept clients' instructions from third parties, they are obliged to execute those instructions differently, carefully, and skillfully. So, what it wants to tell us is, it wants to say when, like, if we think that this is whatever actually we deal in, for example, you deal in X thing, and Y statutes case comes to you, and then you have to, you should be um, uh, not loyal as it, but you should be, should be honest to the client. You should be disclosing all those things. Maybe I am approached by you, and I'm told that I want to be like, I want to be hired as a counsel, and against X, and X is a very dear friend of mine, or maybe we have had some past experiences or past relationships or something. So I must disclose it to you, and if need be, like arbitration may also, you must have read. So if the arbitrator is conspicuous or not conspicuous as it, but if the arbitrator is, there may be um, some questions against the arbitrator, and so that there should not be some personal interest available. There should not be some uh, what to say, like vested interest. And I know maybe it's, you will never do that. Maybe you will not even thinking about it, and you are the most scrupulous, the most principled person that is there. But still, despite that, the legal ethics, they say that you should withdraw from the case wherein anything of this ambiguity is there, anything of this questionable, when you can be asked, when the questions can be raised against your dignity, your impartiality, yes. So that you should be avoiding. And as a legal noble person, so you must avoid all those things which might result in some questioning later on. So basically, because justice may be ultimately, ultimately justice shouldn't hamper. So if that's done to you, and tomorrow the questions are raised against it, so ultimately the justice will suffer. So that should not be the case, and justice should prevail. We have to keep in mind that ultimately justice prevails. Okay. And of course the social conduct, and the social conduct, of course, it's not something that it's teaching you how to make friends, or how to avoid people or something of that sort. No, the advocates should not act towards, as basically social conduct you may add, like you have to you cannot advertise yourself, you cannot talk about your works like this, that you should not be deceitfully soliciting some clients. You should not be doing that. You should not be uh, luring clients. You should not be enticing people that if you come to me, I'll get this to you, I'll get that to you. So basically, social conduct is like, of course, friends are there and everything is there, so your work should speak for you, definitely. But should be you'll be refrained from advertising yourself. You'll be refrained from soliciting. You'll be refrained from putting a word up against the fellow people, or maybe for yourself, putting a word for yourself. So that's something, socially, of course, you will have friends, you will have gatherings and everything, but uh, so you will avoid something socially awkward. Okay, so whatever it requires to profess as lawyers, so you'll do that. But whatever is required beyond that, so of course you'll like you will be refrained from advertising and soliciting clients from other advocates. Maybe that you should leave this person. Yeah, how much this person is charging from you? Okay, I'll do this, and I'll. So you should be refraining from that. So this we have come to an end of a topic which talks about these things, the advocates and their conducts. And these two lectures, they are talking about the advocates and their conducts. And you have to read the like in the unit third talks about Advocates Act, and anyway we'll talk about Supreme Court rules and High Court rules. But this is in general, like these are the conducts that an advocate must be possessed with, must be they should be having these qualities. And if even if uh, don't want to practice law as a practitioner, or as a, but you should be having, as if you're a student of law, you should be having these qualities. We should be having these qualities. And so that ultimately the ultimate aim of law is a noble principle, that is to attain justice, that is to get justice for the people who require it. And the people who, and mostly for those people who cannot ask for it, those who are not, those who don't have vehement voices, and those who don't have means to achieve that, means to get it. So of course you have to, as we talked about, you have to get your bread and butter with that. But keeping in the view, keeping in the mind that this is something very very beautiful. This is something this is the feeling that we must have once in our or more than once, of course. So we must have that feeling that we have done something for the society. We have done something for the, like there's so many PILs that people file, and at the same time, it should not be frivolous PILs, because then, for example, if you keep filing PIL for just no reason, and just to earn some name, or just like that, so it should not be like this, because then the real ones suffer. So it shouldn't be the case. Like keep on filing. Like every day you go to the Supreme Court and file an SLP, file a PIL, and then that's being thrown in the dustbin every day. And because it doesn't have uh, content in it, so that way you actually, because they tend to club things, and then in that way you make the real ones suffer too. So those things, justice, and when we're talking about justice, so justice is something we know that comes, it doesn't come at a cost, I would say, but it comes with patience. So justice is something that you have to help achieve, help the aggrieved person to get. And that's very, that's a very good feeling, believe me, if you help somebody get justice. So one more thing that is there in the PPT, that an advocate must be compassionate as well. compassionate as in, you have to, whenever whatever case you're taking, whatever case you are actually working at. So in this case, first of all, if you're sure that this is a principled thing, this is one of the things that you must take, and this actually requires a deliberation, this actually requires your thoughtfulness, your your time, your devotion. This ultimately actually requires justice. So if you have taken up that case, just make sure that you're very well acquainted with the facts and the legal provisions involved and the statutes involved, and you have to feel as if you have been wronged. Example, if one of your clients is wronged and you're helping that person attain justice, so you have to be compassionate as such. You just don't have to keep minting money. It's not like, it's just not about money. You have to feel the pain of the people, and you have to be compassionate towards that person and see whether this person you know, whenever this person can get justice, and how what can be the shortest way, not the shortest as in quickest, I would say, so that uh, the like as they say, justice delayed is justice denied. So it doesn't get delayed much. And because the system that we live in, because the diverse and the demography that we have, so it's bound to take time, and it takes time though. And because of the quality we have, because just this population and everything, because so many n number of factors are there. But we just need to make sure that the person who needs justice, who has to have justice, actually gets it, and does ultimately get it, even if it takes time. And law should take its course, and it should, like I said, it should not be shortened. Like, it should not be, there are no shortcuts actually. But it should be quick as in, it may be fast tracked, or it may be whenever, according to the facts and circumstances of each case. And then we should unnecessarily shouldn't just delay it. We should not be getting into too many adjournments and all. So so that it actually, ultimately law prevails, ultimately justice prevails. So an advocate must be thinking all these things, so that justice doesn't get defeated. So all the advocates should be doing that, and courts are there to ensure that, of course. And of course, conclusion: the Supreme Court rules provide for detailed conduct of the advocates who appear before the court, of course. So what, and even the seniority, and like we were talking about the in the other lecture, that the Supreme Court has to see, the Supreme Court has to see whether the person can be designated, and even the High Courts see that the person can be designated as a senior advocate or not, and what is the number of years of practice, and all those things will see. And the rules provide the appearance that has to be made by the advocates, of course, and which include wearing gowns and robe and all those things. And check my spellings. So so all those things, you um, this thing, like, advocates must be, like, whatever the rules are there. I told you already that the advocate must be abiding by those rules, and must respect the court, must respect the judges, and must respect the judgments, even if they get defeated, even if they get, they're bowed down, or that has to be accepted humbly. And of course, further course of action, and you have to learn things. You have to learn from the fellow colleagues, you have to learn from the judges, learn from everybody. So it also lays down the principles or the provisions for designating, as I told you already, that he or she can be designated as a senior advocate, or that can be, that has to be, that is the discretion of the court. That is the, that is decided by the court. These are the provisions. There are provisions to do that. So again, uh, this topic, this way we come to an end from our of our first topic, that the Supreme Court rules, whenever the Supreme Court rules, and the we are going to read Supreme Court rules, but the Supreme Court rules vis-a-vis advocates and their conducts. And further, we will add on to these things when we read Advocates Act and some. some provisions in third unit also, third and fourth unit. So we'll keep referring to these things. So meanwhile, just and yeah, whatever we have studied and whatever sources I have provided to you, just make sure that you read from them. And believe me, you're gonna get, because it's a it's somewhat a practical experience. You're gonna get in love with fall in love with this, because there's some theories, there's some principles, there's some virtues that we're going to deal with, and you will automatically inculcate certain things in order to be a good litigator. And one more thing, that is not mentioned in here, that an advocate has to be a good researcher also, so that you, and ultimately, see, you will be eloquent, you will be a good orator. Ultimately, you will actually be courageous and everything, only if you have attained knowledge. If you do have knowledge, you will always feel good, you will always be confident, you will, and of course confidence is one of those things that actually comes with knowledge. And you have to you just don't have to be informed, you have to have knowledge, and you have to transform that knowledge into wisdom. All right, so with this we conclude this second lecture also. And hope to see you soon. Take care.